Good afternoon, everybody. I'm going to give everybody a minute or so to get connected before we get started. If you're just joining us, we're giving everybody a minute or so to get connected. Looks like that has slowed down, so we'll go ahead and get going while people continue to connect for the webinar. So good afternoon, everybody. Welcome to our Lunch and Learn on local agency contracting with independent contractors. I'm Melissa Keene. I'm a senior program manager with the Institute for Local Government and will be your host and moderator this afternoon. A quick overview of what we're going to cover today. We've got only about an hour with you all, so we're going to do some really quick welcome and introductions, and then we're going to hear from our fantastic presenters about some of the new changes to contracting and what that looks like for local agencies as you explore working with independent contractors. And we've got a little bit of time for a discussion and audience Q&A towards the end of today's session, and we will be wrapping up and adjourning by 1 o'clock. Some quick housekeeping before we get started. You've probably noticed that you're muted, and you will be muted for the duration of today's webinar. But please, if you have questions, feel free to share those with us at any point during the webinar. You should see a Q&A box at the bottom of your screen or in the toolbar, wherever you have that located. And we'll be monitoring that throughout today's session. So if you have questions or need anything from us, please connect with us that way. And as you noticed when you jumped in, we also are recording today's session, and we'll be sharing that recording as well as the slide deck and other materials with you all in the next few days. And if you submitted a question when you registered, we also have those. There was a lot of questions that came in before, so we will get to as many as we can today, and then we'll share how you can follow up with all of us after the session if we don't get to your question. So just to share a little bit about ILG in case you aren't super familiar with us, we are a statewide nonprofit that's affiliated with the League of California Cities, the California State Association of Counties, and the California Special Districts Association. So we work together with our local government partners to provide practical and easy to use resources so that you all can more effectively implement policies on the ground. We do that in a number of ways. We do a lot of education and training, such as this webinar, but we also do in-person training and other virtual training. We provide technical assistance, capacity building, and convening services for local agencies statewide. We do that in a number of areas. We have a focus on leadership and governance. So how can local agencies be a better governance team, work together between staff and electeds and the community and what that looks like. We also do a lot of trainings like this around changes to the regulatory environment or new laws that come down from the state legislature that impact how you all do your jobs every day. We have a program focused on civics education and workforce, so helping create a pipeline to public service, get young folks interested in local government as a career path, and help you all navigate some of the recruitment and retention challenges that we know you're facing right now. We have a program focused on public engagement, which really helps embed that into your local agency operations. So how can you do that more strategically, more authentically? How can you account for things like technology and language access and facilitation tips and a number of things there? And then lastly, we also have a program focused on sustainable and resilient communities. So a lot of work around housing and land use right now, but also around climate action and how local governments can better navigate the adaptation and mitigation around climate change, as well as thinking through things like energy efficiency and greenhouse gas reductions and implementing sustainability best practices. So if you're not super connected with us or familiar yet, definitely check out the website. We have a lot of free resources for you all and a lot of trainings. With that, I want to introduce our presenters this afternoon. I'm joined by Catherine Groves and Trevor Tenaguchi from Hanson Bridget, which is one of ILG's great partners, and I'm really excited to hear what you all have to share with us this afternoon. So with that, I'll turn it over to you all to kick us off.
Thank you, Melissa. We appreciate it. And just as a plug for everybody else, the ILG resources are incredibly useful. We use them all the time, so highly recommend them. So thank you for having us here today. We're going to be talking about local agency contracting with independent contractors. If you could move to the next slide, please. So at a really high level, we wanted to tell you that in California, there are two main bodies of law that address conflicts of interest. There's government code, there's the Political Reform Act, which prohibits conflicts of interest in government decision-making. And then there's Government Code Section 1090, which prohibits conflicts of interest in public contracts. Today, we're going to be focusing on Government Code Section 1090 and some recently enacted legislation, AB 334. We're also going to be talking about the Levine Act and some recent changes to the Levine Act, which impact contractors. We have around 32 slides, and I know that we have a variety of different experience levels here today, so we're going to focus on first a broad overview of Section 1090, then get into Section 1090 and consultants, then AB 334 and the recent changes, and then finally we'll conclude with the Levine Act. Next slide, please. So the basic prohibition of Government Code Section 1090 is that a public official shall not be financially interested in any contract that they make while they're in their official capacity. So you can't be on both sides of a deal when you're working as a public official. Section 1090 does not define what a financial interest is, so it's very broadly defined. And the other thing to keep in mind about Section 1090 is that it not only do we care about actual conflicts, but it also strikes at potential conflicts. So if there's the appearance of a conflict, that can be prohibited under Section 1090. Next slide, please. It applies to officers, employees, and certain consultants of public agencies. Officers would be board members, employees are all employees of the agency who are making government decisions. Next slide. Making or participating in making a contract. So virtually any involvement in making or participating in a contract applies. So if you're talking about preliminary discussions or negotiations, compromises, anything of that sort, that would count as making a contract under Government Code Section 1090. Next slide. If a public official has a financial interest in a contract, there is a possibility that they could still participate in certain circumstances. So the first thing we ask if they're a board member is if there's a remote interest that applies. And a remote interest, these only apply to board members. And it allows if one does apply, it allows the agency to move forward with entering into the contract with the board member recusing themselves. If a non-interest applies, and that can apply to a board member or an employee, then the board member or employee can participate in the making of the contract. If there are no remote or non-interest exceptions that apply, and you're talking about a board member who has a conflict, then the agency can't enter into the contract at all. It's a complete bar. Next slide, please. About a decade ago, the legislature enacted a law that allows us to go to the California Fair Political Practices Commission, the FPPC, to get advice on Section 1090. It's actually quite helpful. They issue advice letters, which aren't precedential, but you can review them and get a sense of what other types of conflicts people have. And the other thing that this law did was it allowed the FPPC to bring civil and administrative enforcement decisions after consultation with the district attorneys. The penalties and consequences of violating 1090 are quite strict. So the contract is void and you have to refund the money. There's also a potential felony, imprisonment and fines, attorney's fees, and the public official who violates 1090 can never hold another public office. Next slide, please. So here's an example. The City of Gotham intends to award a 5-year agreement to Best Consulting LLC for an on-call management support services. There's no guaranteed compensation, but the agreement has a maximum not to exceed amount of $1 million. A Gotham council member is an executive of Best Consulting LLC, but oversees that company's engineering unit and has no involvement with the management support services unit of the company. Additionally, the council member has recused themselves from all decisions and discussions regarding the agreement and is planning on recusing themselves when the agreement is presented to the council for approval. The question is, can the city enter into the agreement with Best Consulting? Next slide. The answer is no. And the reason why is because the council member has a financial interest in the company and there's no exception that applies. So there's no remote or non-interest exception that applies. And under 1090, recusal doesn't cure the 1090 issue. So the agency can't enter into the agreement at all. Next slide.
All right, so Catherine's kind of gone through a high-level summary of what Section 1090 is. And I think a lot of you are here to understand, by its black letter law reading, 1090, when you read it, doesn't seem like it would apply to consultants. It says officials. And so when it was first enacted, this is one of the first bodies of laws in the government code. Actually, it is part of the first chapter, one of the oldest conflict of interest laws that we have, or older ones. And when you read it, it says officials. But slowly over the past 70 years, that definition of officials has been interpreted and expanded to include a wide variety of people who interact with government. So in 1956, there's a case, Schaefer versus Berenstein, where a city, an attorney who was a special counsel to the city of Compton was hired through a contract to serve in a role that was essentially negotiating some real estate deals. And the court there found that for purposes of Section 1090, that special city attorney was an official covered by the statute. And over the past, 10 years, it's been expanded even further. And so you have in 1960, or sorry, I skipped over one. In 1963, the legislature added employee to the definition to include both officials and employees of a public agency being subject to Section 1090's prohibitions. And we're going to cover two key cases, one from 2017 and one from 2019, which then expands this definition and application of Section 1090 to have it apply to independent contractors. Next slide, please. So the first case is People v. Superior Court, and I can never pronounce this name, but the name in parentheses is a doctor. This case comes from the county of Riverside, and I'm just going to refer to them as Dr. S. And Dr. S was clearly an independent contractor of a public hospital system. Dr. S served on the executive committee, which was a separate committee, separate and apart from the board of directors that oversaw the public hospital system. But it's alleged that this executive committee, and specifically Dr. S, had considerable influence over the board. They were relied on for decision-making, they provided opinions, they heavily influenced many of the contracting decisions that the board approved or in negotiations that they engaged in. And so the core of this controversy is Dr. S had advised or negotiated the hiring of another doctor by the board. And then it comes to find out that Dr. S had actually negotiated a higher salary and had that doctor's salary deposited directly into Dr. S's own bank account, which triggered some criminal complaints filed against the doctor. And then we get this Supreme Court interpretation of 1090. And so through this, the court rejects a previously held common law distinction between independent contractors and employees. And so there was a split of circuit decisions in which some circuits found that employees, independent contractors could be employees for purposes of Section 1090. One circuit in particular in Christensen found that no, independent contractors were not employees and were not subject to Section 1090. In this particular case, the Supreme Court rejects that interpretation and then finds that specific independent contractors may be subject to Section 1090. Next slide. And the key test that was established here was whether an independent contractor is hired to transact on behalf of the government. And so if you are put in a position to transact on behalf of the government entity in which you have a contract to serve, you are considered an employee or a public official for purposes of Section 1090. And it expands a little bit further, which says influences an agency's contracting decision or otherwise acts in a capacity that demands the public trust. And if we think back to the core of what Section 1090 is, it's to prevent self-dealing by our government officials. And so to the extent a public agency engages with an independent contractor and invests or vests within that independent contractor specific duties and roles to transact on behalf of the public agency, I think it does make sense for a Section 1090 to apply to that independent contractor, because you don't want that independent contractor self-dealing, providing economic benefits to themselves or their businesses. And so the real focus is whether an independent contractor is engaging in or advising on public contracting on the public's behalf. And so there are a lot of different factors that go into it. It's very fact specific when you go through a Section 1090 analysis, but this is bringing us closer to where we are presently. But this is a key case that says, yes, independent contractors that are transacting or engaging, advising on public contracting on behalf of a public agency are subject to Section 1090. Next slide. And so this brings us to Tabor, and this is in 2019. And so in between the Superior Court, the Supreme Court case that we just talked about, and Tabor, there was a flurry of FEPC opinions, a lot more conservative advice given out by legal counsel that was essentially saying if you had any involvement in the first phase of a project, I think the trend amongst the legal community was to then recommend being very cautious because of Section 1090's harsh consequences, to then tell our clients that that contractor or consultant was precluded on working on any subsequent part of the contract. And so that really eliminated a lot of qualified contractors from doing subsequent work on a project where they might have been the most qualified, and in areas where there isn't a significant amount or pool of contractors, may have been the only one able to perform the subsequent work. And so Tabor in 2019 is a helpful decision. Tabor involves a school district which published 2 RFPs. The intent was to have a phase 1 was to develop a plan to modernize their HVAC systems at their schools. The RFP itself, and this is a key fact, explained that the intent of the school district was to hire one contractor for 2 phases, both phases of the project. So even though they were going to let this contract in 2 distinct processes have 2 contracts, at the onset, the intent of the public agency was to award both contracts to the same contract. The school district selected Tabor for the pre-construction services agreement, and then entered into a lease-back agreement, which is the phase 2. So it's entered into a second agreement with Tabor, and then a suit was filed challenging the validity of that second agreement, claiming Tabor was an independent contractor under Section 1090, and because they had a financial interest in the second interest, they were precluded from entering into that second contract, and therefore was null and void. Next slide, please. So was this a violation of Section 1090? Simple answer was no. And I think there are key facts that are important to remember when you're going through a Section 1090 analysis. So the first one, as I mentioned, was that the school district, even though it had 2 distinct contracts, the intent from the outset, from the RFP or RFQ, was to have one contractor do both phases of work. And so in that sense, the court reasoned Tabor had no chance of influencing the public contracting decision of the school district, because at the very beginning, the school district was intending to award both contracts to one contractor. And again, a key factor comes up that Tabor was not hired to engage or advise on public contracting, because the school district at the onset had outlined its entire plan for the project. So a key point of reference or key rule to come out of Tabor, which I think is rolled up into the new legislation, is that consultants providing services to a public agency So providing pre-construction, design, consulting services, geotechnical advice, things of that nature, just providing it straight to the public agency rather than providing services on behalf. So this would be going out and then doing the procurement on behalf of the agency, are not public officials for purposes of Section 1090. This can get a little bit confusing, but I think conceptually, if you think about it, if a public agency is hiring a contractor to help it develop its project, build certain pieces of that project, but then that contractor is not intimately involved in advising it on the particular procurement process, the contracting process it's going to be using, then for purposes of Section 1090, they're not a public official. Next slide. So what specific actions constitute participating in a contract? And I think Catherine mentioned some of these before. There's some based on case law, which are negotiations, drafting contracts, specifications. All of these things readily involve an independent contractor being involved in an agreement. Next slide. I think what becomes more challenging is when you have many or consultant working on maybe a small piece. Now, is that small piece considered participation in the subsequent contract? Again, it's very fact specific, but these are some circumstances in which it may not be actual participating in making in the subsequent contract. They could just be pieces being used by the public agency to develop the subsequent contract. And that's a key distinction. And I think what's really important and can get somewhat lost when you're in the flurry of trying to get your projects out quickly, trying to make rapid decisions to try and meet construction schedules or funding schedules, is to not just focus on one contractor. So if you have a project, you want to focus on the entirety of the project and look at your project may have 5, 10 different consultants, and you want to examine their interests and their involvement in each phase of those projects or the project to ensure that they may not trigger some type of Section 1090 conflict. So an example would be if you have a project manager who's an independent contractor, and that independent, and then you hire subsequent experts, like you have a SQL expert, or you may have a wetland expert, an engineering firm, or a architecture firm, and they're all working together under project manager. You want to examine the project as a whole, as well as each individual entity within it, to make sure there are no potential Section 1090 conflicts that may arise with any subsequent phase work that you're going to be seeking. Next slide. So this brings us to our second hypothetical. And I apologize, the Gotham references are mine, and it was during Halloween, so Batman's one of my favorite characters, so hence the Gotham. So we have the Gotham Parks and Recreation District hired Design Dragon last year to evaluate the agency's website and backend hardware, software and hosting services, and propose options for redesigning the look and feel and backend support for the website. The park and the Recreation Park District staff want to award the contract to Dragon Design. So this would be a second contract for website redesign services, as well as software hosting, maintenance, and support services. So now we have staff contemplating subsequent work, potentially based on the first set of work. Is this okay under Section 1090? I'll give you a couple seconds. It's tricky. Next slide, please. So until the recent passage of AB 334, our position would have been no, and this would have been based on FPPC advice letters. This really comes from the consultant is really being brought in as a technical expert to examine everything, and they have the ability to exert a considerable amount of influence and are really driving what the subsequent public contracting decisions are of the public agency. And so this goes beyond it's more than just ministerial and technical input. It's really, they're being relied on as the experts to drive the subsequent phase of this project. And so potentially with this new legislation, and we can get into more kind of scenarios, it may be permissible. And again, this would be depending on how you structure the initial contract or the request for proposal or the informal bid process. There is a pathway to make it to where Design Dragon would be able to perform subsequent phases of the project. So in general, contractor consultants hired to assess or design a system before AB 334 were prohibited from being hired for subsequent phases of the work in which they designed or recommended to have built. Next slide.
Thanks, Trevor. So what has changed? It used to be about prohibiting consultants from feeding work to themselves in subsequent contracts. That was essentially the analysis that we would go through. Now, what we're looking at is a statutory clarification to Section 1090. There's a government code 1097.6, which goes into effect on January 1st. And now what this statute says is that independent consultants can enter into additional contracts for subsequent phases if their duties for the initial contract don't include engaging in or advising on public contracting on behalf of the public entity. And luckily that's defined, although there's still ambiguity. But engaging in or advising on public contracting means preparing or assisting the public entity with any portion of the public entity's preparation of an RFP and a request for proposals, a request for qualifications, or any other solicitation regarding a subsequent or additional contract. Next slide, please. So the other thing that the statute says is that the initial stage work does not constitute engaging in or advising on the making of the subsequent contract if the participation is limited to conceptual, preliminary, or initial plans or specifications, and that information is provided to all the other bidders and proposers. I think one ambiguity here is, so if the new rule is that the contractor can't engage in advising on public contracting, so they can't engage on preparing the RFP or an RFQ or other solicitation documents, but they can engage in conceptual, preliminary, or initial plans or specifications as long as that information is provided to everyone else. You can see there's a spectrum of activity which is consultant could engage in that might tip into the former category or the latter category. So it's really going to be dependent on the facts of this specific instance that you're talking about. And this is, again, it's about 1090. So it's applies to government contracts. I saw a chat pop up about grant activities. And so you want to look at government contracts. So the other thing to think about here is there's new safe harbor language, which you can include in contracts. If you go to the next slide, please. So if you include this language, and you want to go to the statute itself to pull the language, but if you include this language in the initial contract, then you can rely on the safe harbor protections of the law in any subsequent contract. And this essentially restates what I already said. It's that the initial contract, that the contractor's duties shall not include preparing or assisting the public entity with any portion of their RFP or RFQ, that the public entity is going to remain responsible for public contracting, including with respect to any subsequent phase of this project. Next slide. That any of the initial work that they've done, that any work that they will have done has to be limited to the initial planning discussions or drawings, and that any of that information has to be put into the documents for the subsequent solicitation. And then, of course, that the contractor didn't breach the contractual obligations. Next slide, please. So this, as I mentioned, takes effect on January 1st, 2024. I think some questions here, what about contracts executed between now and the effective date? Our advice has been that those are still under the old rules. So until you get to January 1st, you're under the old rules. If you're in the middle of a procurement right now, you might want to consider waiting to issue a contract for phase 2 work until after the first of the year to avail yourself of this. There's some other ambiguities in this. I'm not going to go into all of them, but I do think that as we start to implement this, we're all going to have questions. And I think we'll want to watch the FPPC advice letters to see how they are interpreting this as well. They traditionally took a pretty conservative approach to Section 1090. And so this is very favorable to public agencies, but I guess we'll have to see how they interpret it. Next question, or next slide, please. So the next question is, the Gotham Water District hired expert engineers to prepare the entire bid package, including all bidding instructions and procedure. Oh, sorry, Trevor, this one's you. Go ahead.
So the Gotham Water District hired expert engineers to prepare the entire bid package, including all bidding instructions and procedures for new water treatment plant. Expert engineers submitted the low bid for the water treatment plant construction, and the water district intends to award the contract to them. Can they? Next slide, please. And no, I mean, this is not covered by the AB 334. The contractor is engaged in essentially contracting or in a procurement role for the public agency, the water district. And so this would be as a clear Section 1090 violation if they were to engage in a subsequent contract with the engineering firm. Next slide. Now there's a slightly different example. So trustee architects and engineers have been hired by the city of Gotham to provide design and engineering services for a new city hall, including the development of schematic designs, preliminary drawings, and blueprints. So for all intents and purposes, they are the designers of this new city hall project. Trustee is also contracted to assist the city through the state's regulatory and permitting process. So this would be, site plan approvals, any type of zoning issues, building code, permitting, etc. After trustee completes its work for this initial scope of work, the city bids the project and selects a contractor to build the new city hall that trustee designed and engineered. The city would now like to hire trustee for a new scope of work to oversee the construction management of the construction project. So just so we're clear, trustee designed the project, it went out to bid, a separate firm is awarded the construction contract, and now the city wants to bring back trustee to do construction management. So overseeing the project, being available to answer questions from the contractor, and then helping the city make sure the project gets over the finish line to completion. May the city hire trustee for that second phase of work? Next slide. And so this is a project that would fall, we think, within AB 334's new provisions. And so it's yes with a caveat, and this assumes the following facts, which is trustee in that initial scope of work for the design phase was not hired to advise in the procurement capacity on behalf of the city for the city hall project. Now, practically taking this hypo to a real world example, there are ways in which you can structure that contract and the procurement documents to make it explicitly clear that there's a clear delineation between a subsequent procurement project. So when a project goes out to bid with a construction firm, that the role of your designer is not involved in that construction phase. And again, this would be separate from like an alternative procurement design method or a project delivery method. This would just be like your traditional design bid build. A second key factor is that trustee did not conduct the city hall procurement on behalf of the city. I think what Catherine was alluding to before, it's still unclear to what extent a independent contractor who's on the design team or project team may be involved in advising or providing technical advice back to, let's say, a panel that's evaluating bids. I think that's kind of a gray area where that may lead into where they could be perceived to be engaging on procurement on behalf of the city. I think that's an avenue that's still being explored and needs to be kind of teased out by the FPPC. The third key factor is whether all potential contractors, so this would be for that second phase, had access to the same information as trustee for the subsequent procurement. And this again is going to somewhat of a new process. It's in the statute itself. And so if you're thinking about at the onset of your project, you may want your designer to also be part of the construction management team when your project is out there, shovel in the ground. you want to be sure that you are documenting everything your contractor, your designer has access to make sure that that relevant information is then being provided as part of whatever subsequent procurement that's going out, in which you may want to hire your designer or your architect or your engineer. And so what really this is trying to strike at is getting into the fairness. So, you know, obviously, if you have someone on board at the onset and they're helping you develop a project, they have a carte blanche access to documents that may not be readily available. So just kind of the key factor you want to keep in the back of your mind if you're putting out a subsequent procurement is ensuring, I think it's going to really require much more robust procurement documents for that second phase to make sure you're covering this basis. So again, 3 key assumptions, factors within this to have it comply with the new AB 334. Next slide, please. And there's one kind of extra, since we're on this topic of conflict of interest laws, that we thought was just important to raise, because this is the public agency community, is the changes to the Levine Act, which took effect January 1st of 2023. It now applies, and for those who don't know, the Levine Act is what's known as like the pay-to-play rules. So it's essentially if you receive contributions before, that only apply to appointed officers, and now it applies to both elected and appointed officers, as well as candidates for elective offices. And it essentially says that if you receive a campaign contribution from an individual who then comes before you for some type of approval in your role on a board, commission, or council, you are precluded from voting or approving on that matter. Next slide, please. And so here it goes into what the actual restrictions are. So it's accepting, directing more than $250 from any party of an agent of the proceeding while it's pending for 12 months after the final decision, or making, participating in making, or influencing a decision. That's kind of a Political Reform Act conflict of interest language there. If the officers receive more than $250 from any party for the preceding 12 months. And based on recent clarifications, this 12-month look-back period starts from Jan 1, 2023. So it's not, doesn't go before that. And I think now we can kind of dive into the Q&A portion. Oh, sorry, one more slide. So here are some of the things. If you have a board member, or you are a board member, or a council member, or commission member, there are ways to cure the defect, and also recusal, again, is not required if you have received contributions in 2022 or pre-January 1, 2023 that exceed $250.
I think one other thing to add about this, if there are those in the audience that are from the consultant community, this impacts the type of campaign donations that you'll be wanting to give to your local officials. It is much broader, you know, have a 12-month window on either side of a government decision. So there are certain jurisdictions you might not want to donate to, because you could then disqualify your council member or board member from voting on a contract related to your work. I think we have one more slide, Trevor, just to wrap up one.
So takeaways, I'm just jumping the gun here because I like questions. So again, Section 1090s are very, very complex and require legal guidance. They're fact specific. And I'm sure many of you are familiar with FEPC opinions. You know, they really only pertain to that specific set of facts. But there could be nuances in a particular situation which may push something to be a Section 1090 conflict versus not being a Section 1090 conflict. I think that the big takeaway here is that now with independent contractors and AB 334, there could be potentially more ways in which you could have a contractor, an independent contractor, work on multiple phases of a project, whereas before we would be very, very hesitant to, from a legal perspective, to say that would be permissible. And so the reality of AB 334 is really, it's a nice statute to have. but you have to do a lot of planning in advance. So if you have a complex project, or maybe not a complex project, it could be a small project, but you could be in an area where you're very limited with your pool of professional services, the consultants that you can draw on. You want to be mindful in how you structure your procurements. And so I think there is a great value in thinking about it at the onset, at the very pre-preliminary project planning stages, to figure out what consultants you may potentially be needing, how you want to structure your procurement, and if there's a way in which, if you foresee potentially you may need the same consultant for multiple phases of work, how to do that to be consistent with, to comply with Section 1090, using some of the tools provided in AB 334. And so I think that's a great new pathway in statute, rather than purely relying on interpretations of Shalaby and Tabor and FPPC opinions. You now have those tools with you, in addition to the safe harbor language, which now alleviates some of the criminal penalty concerns, right? There's that new language that can greatly assist and give a little bit more comfort for independent contractors. Again, don't be afraid to ask for advice from the FPPC. As Catherine mentioned, we do foresee a lot of interesting opinions that will be forthcoming based on how we actually apply the AB 334 to some more nuanced situations where you may not have a clear pathway. And so it's going to be very interesting to see how this evolves over the next 6-12 months. So I would be, if you have a project coming up, I think it's very important to engage the FPPC in getting a clear interpretation based on your specific set of facts. And AB 334 is a great new tool, but it doesn't put a rubber stamp on just allowing any follow-up contract. So again, to stress, planning is key in all of these and avoiding Section 1090. Being aware of your consultants, the financial interests, your pool of consultants, their involvement with your individual public agencies is important, to fully understand and try and strategize like what the best method is in structuring and delivering your projects.
All right, now we're to questions. Trevor, we do still have about 15 minutes to get through some of the questions that have come in during the registration phase, and then that you guys are typing in now. So obviously that will continue to stay open. So if you have questions as we go throughout this part of the conversation, please don't hesitate to drop those in as well. So in looking through the questions that came in and that we're continuing to get, there are quite a few questions around how local agencies can prepare in this space. So does the legislation say anything, or is there any guidance or benefit to having a list of consultants that are quote pre-qualified, or that maybe you have master contracts with, or things like that? So is there anything that agencies can do to better prepare themselves, I guess, would be the general question. Is there a pre-qualification phase or anything like that you guys would suggest, or that the legislation outlines?
I can go first, and then Trevor, why don't you follow up? So there isn't a pre-qualification list contemplated in the statute, but I think what I would suggest is first to add the safe harbor language to your contracts, and then second, plan out, take a look at the projects that you have and these multi-phase projects, and plan out what are the different phases of this project, and who do you foresee potential, what are the potential consultants that could be involved at each phase, and how do you want to scope it so that you can have them involved?
And one thing I would add on too is, as part of that planning, is adding more robust language to your procurement documents. So like the solicitations, you're clearly delineating to what involvement you foresee the contractors having in the project. I think a lot of times they go out with loose scopes of work, especially for like professional design services. It can be very broad. The more specificity you add and the more clear language delineating their roles and responsibilities, that separates your independent contractors, your consultants, from the actual subsequent procurement processes that are contemplated as part of your project, I think will help bring your overall processes and ability to use AB 334 to use a consultant for multiple phases of a project.
Yeah, we've expressly said in contracts before, this consultant is not allowed to perform work on X, Y, and Z phases. So it just sets the expectations at the outset of what exactly they're allowed to do and not allowed to do.
So doing a little bit of homework and pre-planning to map out the types of services you'll need for a multi-phase process and what types of consultants or who you might be going out to bid with, if I'm hearing you correctly. So just doing a little bit of homework, right? Pre-planning. So I think related to something you just mentioned, Catherine, in terms of getting the safe harbor language in and other things of that nature, have you seen or do you expect anybody to be producing kind of templates or anything that local agencies could reference in terms of the language that needs to be used or things to include in some of those RFPs or contracts?
I haven't seen templates yet, but the safe harbor language is actually in the statute. So I would start there. I would pull the language exactly from the statute and use it. That's what we've been doing.
Perfect. And the thing I would add to that is sometimes we know through Cal Cities or CSAC or CSDA or some of the other agency affiliation or associations have listservs or other ways you can ask questions, and oftentimes your agency partners may be willing to share templates or language that they've used. So that would be another avenue that you might pursue as this gets a little bit more developed.
Yeah, I think that'll be a good avenue as you start trying to check out different scenarios when we actually all start applying this.
And I want to add something too, which is this is very much in flux. And so I think there are some clear instances where your templates may be great and you can just add the safe harbor language. I think in other situations, you're going to maybe have to do a lot more. And so I think you're going to want to have your finger on the pulse of this. It's changing very quickly. We've had a stagnation for almost like 30 years. In the last 7 to 8 years, we've kind of gone from employees and officials to now independent contractors, and now independent contractors can work on phases potentially. And so as more FPPC opinions come out, as we have a bigger sample size to understand where the lines are being drawn as far as interpreting some of the nuances within AB 334, I think it's going to be important to be mindful that you're going to have to be flexible over the next 6, 12, 18 months with the understanding that just the safe harbor language, maybe in your particular circumstance, may be tweaked to, structurally within your template agreements.
Yeah, so keeping an eye out for additional guidance from the SPPC as we've talked about, or other changes that may be forthcoming, right? Never exactly. A dull moment. Perfect. I think quite a few questions come in about if there's any interaction between this legislation and some of the CalPERS restrictions. So is there anything that it explicitly says about, if the consultants are, maybe they're retired annuitants, or any interplay between some of the restrictions on hiring former employees or CalPERS designees and this space?
I'm not entirely familiar with that, but my assumption would be I'm guessing the phrase in that would be like if that contract, which would be, I think, an employment contract between, is the question phrasing more along the lines of, does AB 334 in any way impact a public agency's ability to bring on retired annuitants? Is that?
Well, it came through in a few ways, so I was just trying to summarize, but the questions are essentially getting at, I think how you phrase that, like if the consultants or contractors were in the CalPERS system, does that have any impact on the ability to enter into contracts? And I didn't mean to stop you guys.
No, I guess without knowing the particulars, I would generally say the real focus for independent contractors, again, those factors we kind of went through. So What triggers 1090 if you're an independent contractor is whether you have been engaged to transact or act in a role of procurement on behalf of a public agency. And so to the extent that you're a CalPERS member or retiree beneficiary, if you are being hired to develop an entire scope of work and bid documents for a public agency, yes, Section 1090 would apply to you if you're an independent contractor. However, if you're just being hired to provide general consulting advice, it may not rise to the level of where you're designated an official for purposes of Section 1090.
So if I'm hearing you correctly, it has more to do with what the contract is for as opposed to the contractor.
Yeah, that's exactly it. But it has to do with the contract
Okay.
itself and your duties within that contractor rather than your status as a beneficiary.
Okay. I think that gets it.
The
Sorry, go ahead,
1090
Catherine.
I was just going to add the 1090 analysis always focuses on the contract. So that's the best way to think about it.
Okay. Perfect. Okay. Taking a look at some of these others. And I think this is just maybe it's a definition of what the joint powers authorities are, but would joint powers authorities also be impacted by this bill, or is it specific to cities and counties and special districts?
It's also joint powers authorities. It's all government agencies.
Okay.
Yeah, all government agencies are subject, public employees are subject to Section 1090, as well as consultants, certain consultants.
Perfect. And I know you addressed this kind of when it came through, but I just want to make sure that we have it on the record. But there was a question as it related to grant writing. So if I'm interpreting the question correctly, I'm guessing this is an agency or if an agency is seeking contracting services for grant writing activities, would that still apply? So I don't think it was asking if it would apply to the grant funding, but if the contract is for grant writing services.
It still would apply. 1090 still applies to all contracts, all government contracts. So I think if I'm understanding the question correctly, it would still apply, and you need to still think about this analysis. And hopefully you all can't hear my 9-month-old baby crying in the background.
I can't hear. Okay, yeah, so there's some questions around if it applies to IT services or things like that. So if I'm understanding you correctly, again, it's pretty much any contract that the agency might be entering into. So it's not dependent on the exact content. Let's see here. Any suggestions? So there's some couple questions here about, agencies that maybe are used to using the same contractors over and over. Any thoughts on how they can expand that pool, or how maybe this is about the RFP or how the RFP goes out or things of that nature, but maybe getting a larger pool of bids or contractors, or just any suggestions on how to not go back to the same contractors over and over again to decrease some of the implications of the changing requirements.
I would suggest asking peer agencies who they use and figuring out how they advertise.
And I'll just add just a general comment. So, been to several conferences this year, and an overwhelming theme I've been hearing is that there's a significant shortage of professional staff. So engineers, land surveyors, architects. And so to the extent your project requires design services, which I know many smaller public agencies really rely on outside consultants to provide those things that maybe larger jurisdictions have in-house with full-time staff of engineers, land surveyors, design architects, that the pool is getting smaller and smaller, and so they're becoming more and more reliant on several firms, and especially jurisdictions where you may be more rural. There's really only limited selection you have. So I think it's really incumbent on those types of jurisdictions to thoughtfully go through your capital improvement plan, look at your outlook for the projects and the type of projects where you may need really specialized professional services to try and think about mitigating potential Section 1090 issues, and whether that's structuring it as one large master contract and thinking about if that makes more sense, or individual contracts, and then again going through and figuring out if we're going to do it in phases, making sure that you structure it in a way in which would enable to you, if you need to use the consultant at subsequent phases, that would enable you to do so. So again, as both Catherine and I have mentioned, planning is a huge component of this, in order to really derive benefit from the new legislation.
Perfect. Just doing a quick time check. We have time for maybe one or two more questions. So let's see here. There's a couple of questions around, does the new legislation speak to or change any insurance requirements or contracting requirements, again, outside of the what we talked about in terms of if you write the bid and you can't bid on it and that kind of thing, but does it change any of the other requirements around insurance or anything like that?
No, it doesn't.
Okay. Okay. Well, we've got a couple of closeout slides, so I think I'm going to keep going. Obviously, we didn't have time to get to all of the questions that have come in, and some of these seem very specific to your agency. So in that case, I would definitely suggest you talk to your city attorney or your county council or other agency counsel that you might have on site that can probably better address specific instances or specific contracts within your city or county or district. So always a good resource, always something I like to plug as a good resource for you all as well. So just a couple of quick closeout things before we let you all go. Again, if you're not connected with us or not super familiar with us, this is how you can stay informed about new resources we have or upcoming trainings. These are our social media handles and our newsletter. As I mentioned at the beginning of the session, we did record this, and we will share that along with the slide deck with you all that are on the line and any of your colleagues who may have registered or weren't able to attend within the next few days. And then want to share contact information for our speakers and myself in case you have anything to follow up that we didn't get to or that you want more clarification on. But Trevor, Catherine, any final thoughts before we close out today?
Thank you for having us.
Same. It's a great seeing everyone virtually.
Yeah, thank you to our attendees for sharing your lunch hour with us to hear more about some of the changes to this legislation. And huge thank you to Catherine and Trevor for sharing all of your expertise with us and walking us through some pretty complex things here. So thank you all and have a great afternoon.